Hey, everybody, welcome back to the weekly immigration news recap, where we break down what changed in U.S. immigration this week and what signals came from the Trump administration that could impact your immigration situation if you're a foreign national or your client strategy if you're a practitioner. Today is Thursday, October 30th. It's about 11:18 a.m. Eastern Standard Time, and this episode is going to be released tomorrow morning on Friday, October 31st, Halloween. So to recap the news with me this week, I'm really lucky to be joined by Lynn O'Brien, immigration attorney and immigration practice leader at Womble, Bond, and Dickinson. Lynn, welcome and thank you so much for joining me today. How are things going for you in the DC area?
Thank you. Things are good. We've had a lot of excitement as per usual in this administration, and I think it's really apropos that this will be posted on Halloween because we've had scary news all week. So I think that, we're doing as well as we can here on the immigration team.
Well, so Lynn, we're gonna get into all of the immigration news from this week. We were talking before we started that for once on this podcast, I don't want to say I got lucky, but there was some breaking news that didn't happen on a Friday. It happened on a Wednesday before we recorded, so we'll actually be able to cover that in a timely fashion. But before we get into all of that, can you tell folks listening a little bit more about your professional background, your current practice, and the types of clients that you're supporting?
Yeah, so I'm a business immigration practitioner. I had a career that started as a paralegal before I went to law school. And after law school, I worked at a boutique immigration firm, learned a lot about all of the different, business categories. Then I actually was a contractor at USCIS for a couple of years. They were working on the USCIS transformation project at that time. It was really eye-opening to be sort of inside the, belly of the beast, if you will, but it gave me a lot of great insight into how the agency works and how long it can take to get decisions, and also like reactiveness to certain things. Um, when I was on that project, I remember there was an announcement for TPS for Haiti. And I was, with some of the executives when it happened, and that was pretty exciting. But I know other parts too of the transformation project where I was like completely surprised by how things were run and how they were operating. But after that, I worked at Barry Appleman and Leiden for a good amount of years, and so had the fire hose of volume work, and also took on I visas, which are for foreign media representatives. So that was a new type of visa. I loved anything new where I could learn. And I also represented, like, IT consultants before that was, like, much of a thing. So, I remember one day I had 50 RFEs that were all due on the same day, and that was, like, back when you had to file all of your H-1B petitions, like, the whole petition and wait for it to get mailed back. So, I had been part of a project where we filed, 2,000 CAP petitions for one client, and about 1,000 were selected, and so that resulted in, a lot of action at the same time for a lot of those cases. So, really, it was, a great exercise in learning how to be efficient and the things that you want to do in your practice, but also, of course, being nimble because the RFEs you got at the beginning of the summer were not the RFEs that you got towards the end of the summer. So always, being nimble where needed. And now I'm at an AmLaw 100 firm, Womble Bond Dickinson, because I wanted a little bit more creative license and to be a little bit more entrepreneurial. So I'm leading the practice here. I'm still doing business immigration, but because we're like a multidisciplinary, sorry, multidisciplinary. No, a multi-practice firm. I'll just say that because we're a multi-practice firm, there's really nothing I can't do because I can pull in, white collar criminal investigations if I need to, and that has come up. And, we have compliance, employment attorneys. If, something is sort of a little bit outside of the regular realm of what, investigations look like. And that's been, fun because, again, you get to be creative. And then, of course, there's everything that I know and love from, being a business immigration practitioner.
Are your colleagues in different practice areas pulling you in more often, in the last 10 months than maybe they did before?
Yes,
Yeah,
for sure. I had never been involved in like a grand jury subpoena until I was here. And, some of the things that I'm getting asked to do are just unique. And
yeah.
honestly, I don't even think a year ago, no matter what firm you were at, I don't think a year ago there would have been such a need for just almost like a subject matter expert for certain types of investigations going on.
Yeah.
So
Yeah, immigration compliance, sponsorship policy inside of companies in the last 10 months has pivoted very quickly for a lot of companies to a not just a C-level sort of topic and conversation, but a CEO level topic and conversation. And we've seen that some of the public remarks from, the CEO of NVIDIA, I think famously talking about the 100K H-1B fee. And so I
yes,
uh
they did.
I imagine for the clients that your firm represents, immigration is more important than ever before for them, even if that's not the main practice area that you represent them in.
Yeah, that's correct. I get a lot of one-off inquiries from like a firm client who they didn't even realize they had an issue until some event happened, or, someone comes to them and says, like, this actually isn't my name or ID, but I have one now. And so they want to come clean because they're afraid of, what might happen. It's been a very interesting year. So,
I imagine. Well, we're gonna just sort of bite off a piece of that today with some of the stories that we're gonna cover, and we're really grateful to have you here to share your point of view on everything in the news. But returning listeners will know that we do our best on this weekly immigration news recap to recap as much of the new immigration news as possible, but we also focus on the key developments that we think are most relevant to our listeners, which are primarily immigration practitioners. And so yes, this is a news recap, but it's a forward-looking podcast, and it's my goal to bring you new information that you haven't heard anywhere else on the immigration news of the week, and to feature the POV of our guest today, Lynn, who, as a practitioner at an AmLaw 100, managing the ramifications of all of these new policies and trends that we're going to discuss today on behalf of our clients, brings that on-the-ground perspective. And then at the end, we'd love to save a little bit of time to just pick Lynn's brain on some a trend or a signal or a development, something that she's paying attention to that maybe isn't in the news this week, hasn't been in the news the past couple of weeks, but might be important for practitioners, for foreign nationals, for companies going forward. So, with all that housekeeping out of the way, Lynn, are you ready to jump into the news?
I am ready. Let's do it.
Awesome. I'll go ahead and share my screen with the first story. So this was the big news from yesterday, Lynn, which is that DHS announced that they would be ending the automatic extension for employment authorization for EADs, and we learned that would take effect. That would take effect starting today, October 30th. And
Yes.
so not a lot of notice. It sort of took over the LinkedIn feed for immigration practitioners yesterday. I'm showing the announcement here on the screen, or at least a summary of it, the summary of the new rule for folks who are watching. They can check it out, and for folks who are listening, I'll link it in the show notes so you can go ahead and check it out if you haven't already. But I imagine you have. So Lynn, when you saw this announcement yesterday, I guess what was your initial reaction? Number one, and then number two, I guess like break down what this means for your clients and for the clients of other immigration practitioners out there.
Yeah, I think for clients, it was, another instance of, having widespread panic at, companies, and then also widespread panic from the individual employees that work for those companies, and trying to calm them down with having, little bits of information, not knowing if litigation is going to follow, presuming that litigation is going to follow just based on the near effective immediately way that this, came about. And I think, for H4 EADs and for those who have, adjustment of status applications pending for those types of EADs, I can only imagine that the stress of like the ability to file is only 180 days in advance. And knowing that the ability of you to have continuous, work authorization lies within the hands of an agency that is not prioritizing how to be helpful when cases are backlogged is just a frightening, premise. I mean, in today's world, when you have an extension and you have this automatic, 540 days while it's pending, you're as a company, as an employer, you're not worried about, what's going to happen because there's plenty of time to get that approval. And what that means is that your employee is actually focused on the work that they've been hired to do. When they are counting every day on, this timeline of when do I lose work authorization, they now have a whole new part of their day, and it's going to take up so much time, especially from, HR and those who are gonna have to figure out how do we put them like do we have to take them off of payroll? Are we gonna put them in a leave of absence? Like, how are we gonna handle this if by the time the EAD expires, they can't work? And I mean, this is like it's a ripple effect, right? So first it affects the company, then it's gonna affect the productivity. It's gonna affect that, individual with the EAD personally. And what are the options for them to try and get this done more quickly? Well, you can't file, more than 180 days in advance. I think I'll test that and I'll try, right? Because when you file an H-1B amendment, if you file the H-4 and EAD with it, sometimes you get lucky. So I'll be pushing all the envelopes. Maybe you have to get creative. You're probably going to have to call customer service and make expedite requests, although those sometimes feel like they just go into a, black hole. I've always been of the opinion that if there's no fee attached to it, then they don't pay as much attention. And the priority of, this, regime within USCIS is not customer service. So I don't expect that, these like expediting requests, if you're at day 175 and you can tell from case processing times that it's probably another month, I don't think that expedite requests are going to be looked on as like, oh, this is really urgent because, they're about to lose work authorization. Probably congressional offices are going to be contacted a lot more than they used to be. The other thing that I used to do if an EAD was coming up against the deadline, back when there actually was a 90-day clock within which the decision needed to be made, I mean, the office of the USCIS ombudsman would, take a case assistance request when the 90 days had passed and they would triage it immediately. I mean, that whole office is gone. So there's going to be limited avenues for someone who is going to lose work authorization and it could cause like a personal, problem in their situation with, needing money or wanting to maintain like, continuity of employment. But also the employer is going to be left scrambling, right? Because an employer will have a decision to make. Well, if EAD processing times skyrocket, am I going to hire a temp? Am I going to stop hiring, foreign workers, which I would imagine we already had Walmart come out and say like they're not going to sponsor H-1Bs, so our company's going to make policies against, EADs. And will that be a policy that applies to only certain EADs, or will they apply that to broadly say, okay, we're not going to sponsor green cards anymore because we don't want to deal with your, your permanent resident, your EAD incidental to your green card application. I mean, I could come up with the parade of horribles that could, come from this one announcement, like pretty easily.
Yeah, you filled in, I think, a lot of the important details there from the announcement. One of the things I wanted to zoom in a little bit more on, and I posted about this on LinkedIn yesterday, right? As you mentioned, at the core of this announcement, there's no longer the 540-day automatic extension of work authorization upon filing the renewal. So now more than ever, the actual processing times that it takes for an I-765 to be approved by USCIS matter a great deal because, like you said, as of right now, you can't file. I mean, I'm glad to hear that you're going to experiment with it. I'm looking forward to hear the results of those experiments. I hope they work out in your client's favor. But like you said, as of right now, you can't file those extensions, those renewals until 180 days prior to the expiration. So with lawfully's data, as listeners know, unlike USCIS, we're able to report on actual real time processing times. USCIS does report on processing times for H4s, for 765s, and for the pending I-485s, the pending AOS cases, the 765s for those. But it's a lagging metrics, so it's telling you how long it took most of the cases in the prior 6 months to be processed, not how long it's taking now. And so I posted this on LinkedIn yesterday. For those who are watching, they can see it. But for those who are listening, for the average that we tracked lawfully in September for H4 EADs was 5.9 months. And then for EADs, for cases with a pending I-485, it was 4.7 months. In both of those bars, both of those trend lines are going up slightly, and have been over the last couple of months. And that's obviously going to be a big concern in terms of, like you mentioned, Lynn, there being a gap in work authorization for individuals, but also for the employers that employ them, and those employers figuring out what their options are for actually keeping their employee in status and able to be employed. I want to sort of pick your brain on this. So the reason I posted these two trends yesterday is because, just anecdotally, I know a lot of companies where, in terms of their total foreign national, employee population, folks who are working on a EAD with a pending AOS or an EAD, H4 EAD tied to their spouse's status, tend to make up a large portion of total EAD holders. F1 is probably the largest for most companies, but that's not impacted by this rule at the moment. Are there other groups amongst your clients that could be impacted by this rule, who are currently working on an EAD or may need to extend or renew in the next couple of months?
So I think these two that you've represented are the ones that are going to be sort of the most concerning for the employers that I represent. This doesn't apply to, I mean, anyone who's in L1 status and the L2 spouse is working. I mean, that's incidental to status. So if they did get an EAD and it was expiring, they could just travel, come back in, and they're work authorized because it's incidental to status. And the same thing, if the principal applicant in E2, like those spouses are also work authorized, incidental to status. So from a business immigration perspective, the H4 spouses and, all of the adjustment of status applicants that are, especially the ones where the company does not pay for them to maintain their underlying visa status. So some companies might say, okay, once we we'll support filing the green card application for you. Once you have your EAD, we're not going to continue to extend your H-1B, or we're not going to continue to extend, whatever underlying status that you have. And I mean, for some companies, that financial decision has really made sense because, maybe the employee doesn't really travel that often. Maybe they've struggled to get H-1Bs approved in the past, like who knows? So having that EAD just as the, single thing to maintain was always fairly easy. With this going away, anyone who the company doesn't sponsor the underlying, status and continue that going, they're probably going to be asked by the employee population, like, if they will keep that going. And I would imagine that request is going to come in fast and furious because, there's already so much anxiety that comes with any kind of change. And I mean, we all saw that with the $100,000 H-1B fee. That, people's anxiety level when they're sponsored, it's probably already the highest I've ever experienced in my career. And I mean, I practiced during the first Trump administration. I've practiced over, Republicans and Democrats. And this is definitely the most um, stress inducing that I've seen for companies and employees alike.
What are sort of the next proactive steps for immigration practitioners, for both attorneys like yourself, but also the HR immigration leaders, the global mobility leaders at companies, to now plan with this announcement in mind? Like you said, there's a lot of known unknowns out there. Litigation could throw a wrench in this interim final rule, and it could pause it for a period of time. That could also not happen. It's not like USCIS gave you and your clients or any other company very much time to prepare for this, and get a bunch of filings in, or as many as possible before today, because I think there was like 18 hours from when this was published to when it was in effect for new filings. What are the proactive next steps for firms, for practitioners, and for companies right now, on this rule?
Yeah, so some companies take a less active role than others. So, for example, if a spouse wants to apply for the H4 EAD, they'll supply a copy of the approved I-140 to make that easy for them. But they're not covering the cost and sort of the employees on their own. And those companies are probably going to be asked by the principal, beneficiaries, can we start tracking this? Can you file it? Can you get your attorneys to file it? Like, I'll pay for it, but like, we don't want to have to do this ourselves. I think that sort of just to show that the employee is very supportive of their employee population, they likely are gonna get looped into having a larger role in, timing of these things, so they're gonna get asked by the employee, like, nonstop to hurry up and file their extension application, right? Because if you're filing the H-1B along with the H-4 and the EAD, you wanna file them on, day 181 so that they're accepted on, the 180th day to, in advance to make sure that they get the full, time that they can for hopefully the adjudicator to have enough time to get to the approval. Sometimes for H-1B purposes, it's hard to get budget approval, or maybe they are in the promotion process, so they don't want to move forward until they know what the new, job is going to be, and, new salary or new job description. So instead of, hurrying to file an H-1B and then having to file an amend, like, the employer might have an interest in just, holding off for, a month or two until they have, like, the latest and greatest information. But the employee is gonna say, "Yeah, but then my spouse will have to stop working." And so this is gonna be, sort of this dilemma that employers are now gonna be looped into. And so employers are gonna have to plan for, what are they gonna do? If they have a policy, like, are they gonna have exception criteria? If they are gonna make an exception, like, how do you do that equitably? Um, you know, if you have just someone's manager, like, willy-nilly says, "Oh, we'll cover it," but then someone else's manager says, like, "That's not my problem." There's all sorts of questions that can come up, and I think companies, especially today, probably need to be talking to their immigration counsel to find out, okay, what are we gonna do? If we wanna help as a company, what does that look like? And how can you help us, track these things? How can you help us file them? How can we expedite them if we need to? You know, do you have ways of making congressional requests if we want to do that? and, all of the different types of inquiries that they are going to get over the next, however long we have this as, the new way of the world, I suppose.
Yeah, all very, very good points, and everything you just said there, all of those scenarios that you just went through are a great example of why folks out there hiring a smart immigration attorney like Lynn to manage your cases is really important because she's seen it all. And a lot of immigration attorneys out there have seen all of what's happened before, and there are new scenarios happening now that nobody's seen before. But you want somebody who really understands all of the factors and variables at play to help you strategize for the future because your workforce it's not sugar it's not being hyperbolic to say like a good chunk of your workforce or your whole foreign national workforce could be at stake depending on what decisions you make now in reaction to some of these developments. And I'll just give a quick plug before we move on to the next topic too. If you're an individual and you want to track your EAD, your pending EAD case, go into the mobile app, go into the App Store, download or search for lawfully, download it. You can put your receipt number in, and you can see your case compared to all of the other foreign nationals, all the other tens of thousands, hundreds of thousands for all EADs actually, of foreign nationals who are tracking their EAD application that's pending with USCIS right now. And you can see when others are getting approved, when they're being adjudicated, and sort of where your case compares to those. And then same for practitioners. If you want to see that view, but for your entire client, all of your clients, or for your entire workforce, if you're a company, we can give that sort of level of transparency as well.
And, if you don't mind, I'll say one more thing, which
Please.
is, for many companies, there are sort of super users sometimes. So it may be that you have one business unit that works on, engineering of autonomous vehicles, right? And so the people in that business, have a lot more employees that will be impacted. So, really looking at where do all of my visa holders sit within the organization and coming up with a, continuity of operations plan is probably not something that anyone else had like on their bingo card for EAD holders, right?
Right.
So, this is just adding another layer of we have to make sure that the company doesn't have like an impact in their projects, their timelines, and, their service delivery.
Yeah, 100%. Okay, moving on to another rule that is not here quite yet, but is in the pipeline. A couple of weeks ago, this new rule that is very vague right now, but it's in sort of the first stage of the immigration DHS USCIS rulemaking process, which is it's under White House review. So all we know about this proposed rule is what I'm sharing on the screen right now, and I'll just read it out for those who are listening. But DHS is proposing to amend its regulations governing employment-based immigration petitions in the first, second, and third preference classifications. Skipping ahead a little bit, they call out in particular EB-1A, EB-1B, and EB-1C, and EB-2 NIW, and just the fact that when the final text of this rule comes out, it's very likely that there will be reforms to the criteria to qualify for these visa types. That's somewhat speculation, but it's informed speculation just based off of what we know the administration's priorities are and sort of what this rule is signaling. Lynn, I want to go to you for sort of your reaction and to talk a little bit about sort of what you've seen in your practice with USCIS adjudication trends for employment-based green cards for I-140s over the last couple of months. But real quick, just switching gears here to a story from Stuart Anderson, who's a great reporter from Forbes. He wrote a piece a couple of weeks ago, and it was primarily about the H-1B visa. But tucked in there, he cited an interview that he did with a former USCIS official named Efren Hernandez, and they were talking about what Efren thinks the administration's goals are for reforming the current sort of employment-based green card system. In there, he speculated. I think well-informed speculation given his previous career at USCIS, that it's possible that the proposed reform could increase, the threshold for criteria that needs to be met by an applicant from 3 out of 10 for the EB-1, for example, to 5 out of 10, which would basically just raise the bar. So, all that said, Lynn, folks who have been following us at Lawfully know that we've been tracking in real time the declining approval rate for EB-1A I-140s and EB-2 NIW I-140s since March. That approval rate has continued to decline for both of those case types through September, and we'll see in a couple of days here whether or not anything's changed through October. But what have you been seeing for employment-based green card petitions in your practice, and sort of how are you advising your clients to think about their filing strategies over the next 6 to 12 months on the employment-based green card front?
Yeah, so for the first time in a while, I am being asked to do consultations with people who have three criteria, let's say, but they know one is a little bit weak. And so they want to know what they can do, like what steps they can take now to have a stronger application. And some of that is really outside of the box thinking with like, okay, well, you're working on an article, like when can you get that published? Like go out there and get invited to peer review something, and it's things like that. But for someone that has a unique, area of expertise, it's, okay, well, all right, let's get you a publicist. We're going to get you some more media attention. We're going to, get you on some podcasts and, maybe you can get picked up in an article in some of these very well known sources. I mean, this is the kind of thing that, you know, is the difference between like having an attorney who sees the RFEs and like how to build the narrative and build the story in a way that is, palatable to, like the immigration services officers. It's, can you Google yourself and, find out who you are, what you do? Like, is it someone that is impressive in the field who is, talking about you? Those are the kinds of things that we know that, are important at this point. Um, there's so much vetting that's going on, which I guess we could have mentioned that with EADs as well, since they said that was, the reason for this. But we know that even, looking at social media, that can happen. There's so much data sharing that can happen. You have to make sure that the narrative that you're telling is the narrative of your career, right? So if you last year were, I don't know, a senior software engineer, and now you're telling the narrative of how you have extraordinary ability, well, how? How are we going to build that? How do you make it believable? If, maybe all along you shouldn't have been in that position. Maybe you settled because you were afraid of moving on, right? The economy is a little bit strange and scary. If you're in the green card process in a different type, right? So if you have a perm, that you were kind of waiting to get an approved I-140 before you tried, another category that was going to be less palatable to your employer right away. There's other reasons that someone's career trajectory at first glance might be different than what you would typically have for, this type of case. If the criteria increase, it's only gonna take even more, like, creative solutions for how is this person gonna qualify? And if realistically you don't think the person is gonna qualify, then how can you build up what, what criteria they do meet, to then meet some other criteria as well?
Yeah, and it's no secret that this is available in the public USCIS data, but I think if you just pay attention to the overall market, their USCIS quarter over quarter has been receiving significantly more EB-2 NIW I-140s and EB-1A I-140s for about the last 3 years, right? So more and more people are throwing their hat in and trying to get a green card through that pathway. Like I said, over the last 7-8 months, we've seen declining approval rates for both categories. There's sort of a split there. It tends to be a much lower approval rate for regular process cases, and the processing times right now are anywhere between like 8 and 12 months for EB-1A and EB-2 NIW. So a lot of those cases were filed during the Biden administration.
Mhm.
We'll eventually see, maybe in the next couple of months, the text of this proposed rule, and that will tell us more. It'll tell you more to share with your clients about how to potentially shift sponsorship strategy for the not the self filers, right, but for the employers to shift sponsorship strategy for which of their employees might qualify for this petition, or either one of those pathways or not. But I think it's fair to say that one of the goals, actually, Joseph Edlow himself, the USCIS director, has said this. One of the goals with not just this rule, but many of the rules, is to decrease the volume of applications coming in, because that is how they're going to, as Edlow has proclaimed, his goal is decrease the backlogs. That's one of the devices for it. And I think that might be the results of this rule if the bar is raised.
Yeah, I think you're right. I think with EB2 NIWs, another thing that, eh, applicants need to think about, or beneficiaries need to think about, is, you know, how is what you're doing, is it in the national interest of the United States according to the agenda of the current administration, right? So, a couple of years ago, if you were working on vaccines, like, or the COVID vaccine, like, that was hugely in the national interest. If you're working on vaccines in today's world, like, is that actually in the national interest? If, we have RFK Jr. If there are political reasons that might not be convincing anymore. And so how are you reframing that, right? So is this about competition with China? Is this about some other area instead of how you would have framed it a few years ago? Like, again, are you thinking outside of the box and looking at that in creating, the story that will, kind of wrap around how you meet the criteria. And I
Yeah.
mean, there's no one way to do this, right? But it takes, thinking about all of those, like, potential mitigating factors, such as, political and, economic factors, to, make a successful case. And I think that has been um, a unique challenge that has become more prevalent. And I think also with, like, just the sheer number of executive orders, and trying to know what is in the national interest, like having to make sure you've got proof that, something is in the national interest, and that you're citing to that if that's the type of, application that you're going for.
Yeah, absolutely. Okay, well, one sort of more story, it's more of a continuation of a story that we probably can't, we won't not cover in this podcast for the foreseeable future. And that's the H-1B program and sort of the current state of it. And so for the last couple of months, there's obviously been a lot of news about H-1Bs. Around July, August, and we started tracking on this podcast, you started to see an increase in public rhetoric from USCIS Director Joseph Edlow, from Stephen Miller, from Republicans in Congress and in the House and the Senate, and from sort of outside right wing influencers, criticizing the current state, the current makeup of the H-1B program. That obviously culminated in the September 19th announcement about the $100,000 H-1B fee, which we got a little bit more clarification on, and we covered in last week's news podcast about who that applies to. There's also potential changes to the lottery coming that we've covered, Project Firewall from the Department of Labor. But now a new update this week, and we love to sort of show clips when we can. Republican governors are taking it in their hands to try to find a way to reform the H-1B program within their power. So I'm going to share a quick clip here for those who are watching and listening, and then Lynn will go to you for your reaction.
It ends up being this way. But I think it's a poor reflection on some of the decisions that some of these universities have made, that they're trying to say they need an H-1B visa to do some of these jobs, and clearly some of them are not even close. So this is not like you're taking an Einstein and you're bringing an Einstein from a foreign country to teach all these great things. First of all, you wouldn't even use an H-1B visa for that. You would use an O visa for that. So these are not like super, sure. This is basically, in some respects, cheap labor that they're bringing in to try to save money. So we saw the results of that. We thought a lot of it was, quite frankly, troubling and disappointing. And so I'm directing today the Florida Board of Governors to pull the plug on the use of these H-1B visas in our universities. We can do it with our residents in Florida or with Americans. And if we can't do it, then, man, we need to really look deeply about what is going on with this situation.
So, Lynn, obviously, for those who are just listening, that's the governor of Florida, Ron DeSantis, talking about how Florida universities, which I was looking at the public LCA data on H-1B on H-1Bs for Florida universities, and it's quite high. There are hundreds of them every single year for the different universities in Florida. New sponsorships for H-1Bs, which are obviously for the most part cap exempt. What do you make? And we're going to talk about the 100K fee in a minute, but what do you make of this sort of rapid shift in the last 3 months where the H-1B program has become front and center for this administration, but also for the broader, I think, Republican Party? And their point of view is that the H-1B program, as it currently stands, is not beneficial to Americans, needs to be reformed, and we're seeing that rhetoric turned into action right now. So what's your take on that, and sort of how are you talking about it with your corporate clients? How are they thinking about this massive shift that's now going to impact many of their employees and the future of their companies?
Yeah, so I mean, if you're representing a university, this scares you to death, right? Because they're wondering, well, okay, I'm not in Florida, but what's going to happen where I am is there going to be political pressure for the leaders in, the state where we sit to have some type of, similar announcement to, cut off sponsorship? And if you're a company, this is interesting because you're wondering, well, does that mean there's, going to be a larger applicant pool that has talent that, maybe will be able to fill any openings that we have? Um, I think the interesting thing that I have as a takeaway though is if you remember the first lawsuit against, the H-1B, the $100,000 fee, you know, educational institutions are a part of that, and they're saying, "How could you expect us, along with nonprofits, to pay this $100,000 fee?" And I think it's quite intentional that there was no exemption for them in that proclamation, and I think this is just another way to kind of squeeze the ivory towers, if you will, and the universities to stop using the H-1B category. Um, I'll be interested to see how the litigation goes, but frankly, I'm not super surprised that this is happening because I think, you know, based on the fact that there was no exemption for this type of organization or institution from, the presidential proclamation as it was written, and there still hasn't been any clarification of it. I think at this point it's intentional that it's not there because they could have, added, oh, and there's an exception for this when they came out with, FAQs and when they've come out with more and more guidance. So I think this is just showing us another trend that, maybe DeSantis has been like the first one on the stage to say, you know, with a lot of force that, this is the stance that their state is taking. But I would imagine that this is just, sort of a sneak peek at what's to come.
Yeah, I think you're right that the ripple effect is the story here. There's 27 Republican governors in the U.S., and many of the universities in the states that they represent are very large users of the H-1B program. Like for folks who haven't looked at the data before, Columbia University, the University of Michigan, University of Arizona, many of those universities sponsor hundreds of employees on H-1B visas who are doing a range of things on those visas. Lynn, last item on this story, and then we can sort of jump into something that you're tracking that's under the radar before we wrap. But you guys actually wrote you and your colleague Joe Whitley wrote a great, I think, like FAQ on the current state of the $100,000 H-1B fee. And I was reading through it, and I thought, and for those who are folks who are watching, you can see it right here. For folks who are listening, I'll link it in the show notes as usual, so you can go check it out. But you had just a couple of situations here in the FAQ that you wrote, and then you sort of gave responses to whether or not the 100K fee would apply to those situations. And this came after we got that clarification from USCIS that, at a broad level, if you're a change of status, you're clear of the fee, or if you're an extension of status, you're clear of the fee. But if it's a new H-1B petition that's consular filed and you have to, get a visa stamp at a consulate overseas, you can't return to the U.S. or you can't even file that petition rather until the 100K fee is paid, and there's now a payment link set up for it. So I'm really curious, and again, I'll post this in the show notes so folks can go check it out. But from you, I'm really curious, like what are the current conversations that you're having with your clients on how to strategize for this 100K fee? There's obviously the litigation, two very serious suits that have been filed against this fee that could lead to an injunction at some point. But as of now, the fee is due for certain applicants who want to come into the states on an H-1B visa, a new H-1B visa. But so what are the strategic conversations that you're having with your clients as it stands now?
So I will say, I'm almost hesitant to put this out here because I feel like USCIS is going to watch it and, and then like crack down on, what I see is like, a way for a company, like, you're identifying the talent you want. Like if I am a corporation that has come to have thousands of employees, I feel like if I was the CEO, I would be like, how dare you tell me how to run my business and who to hire?
Right.
But I think, what is a likely scenario is that, there is talent at these companies and they might, instead of, sponsoring someone who has been untested within the company, they might look to, especially global companies. If you have an entity outside the US, bring them in on an L because then they can do a change of status within the US and then you're not subject to the $100,000 fee. Not every company can do that, right? Because they don't all have offices outside the US. But I would take a similar approach in, what other visa categories might be, available to this individual that you have identified that, you like the way that they work and you want to hire them. If it's an unknown resource, just from outside the US that for whatever reason, someone just really wants to hire them, it's going to be harder, right? Because you're going to have to spend a lot of strategic time to think about how would we do this, especially if they don't already work for you within, another entity of your company. I mean, there are ways that I'm sure you can think about doing it, and I would imagine that a whole industry of, contract providers will probably pop up to see if they can, find a solution in the market, because that's usually what happens, right? But, the other thing to keep in mind is that, there's no quick fix, right? So you can't just have people come in on Bs and then do a change of status because the proclamation already made, a comment that, we're going to keep an eye on that. So it's just another thing to keep in mind as you're strategizing. You probably don't have all of the visa types in your arsenal when you begin this, strategy session to think about, who are you going to sponsor and, how much is it going to cost?
Yeah, it used to be, if you were head of global mobility at a company, you ran, the U.S. immigration sponsorship at a company, you could put together, sort of like a policy manual for your company and sort of what your sponsorship policies are. That has to be a living document now these days. It has to be a live shared Google Doc with your immigration counsel if you want to try and keep
Right.
up with everything. So,
No, yeah, actually, very large companies asked me to look at their policy. Actually,
yeah,
I'm trying to have it done by tomorrow, and I think it's just so apropos because there's going to be so many changes. They haven't updated
yeah,
it in years, so
yeah,
it needs refreshing, but I think, like, I don't think they imagined the number of things that they, have in there that are not really the way that things can be done anymore.
yeah,
So, I guess just another call out to employers that, like, yeah, you need to look at your policy documents and
yeah,
make sure that if you do have a way that, HCAPs are nominated, that, maybe it's just based on, who a manager wants to have, like, that might not be enough criteria anymore. It might
yeah.
be, you have to have a budget for each, business unit or however you wanna structure it to make it work.
Yeah, exactly. That itself could make up a whole series of podcasts, that topic. So we'll have to
Exactly.
have you back on to talk about that soon. Well, Lynn, I want to be cognizant of time here. Before we wrap up, we talked about a lot of the pressing, immigration news, employment-based immigration news today. But are there any trends or signals or developments, maybe bubbling under the surface of the Trump administration that you're keeping track of because you think it might be consequential for your practice and for your clients in the coming months that you wanted to share or talk about?
Yeah, so a couple of things are sort of, and again, like, I'm a little bit of a conspiracy theorist just because of where I sit and where I've practiced. But, data sharing really has caught my eye because there are so many MOUs in place and so many different agencies that are sharing information now that I think that companies, if they do have background checks, like, are they gonna expand that? What is that gonna look like? Do you want an employee to, file a FOIA request before they fill out a DS-160 application to make sure that they don't have some glaring issue that, legal counsel could spot where, that's gonna land you in administrative processing, and then we probably, wasted all this time and energy and money on this, and it's not gonna be fruitful. So I think, keeping an eye on data sharing is important. Um, the other thing is, like I said, I think nonprofits and educational institutions may not be cap exempt to the extent that they are. That could be a huge, change. And I mean, even remember, because some people have concurrent H-1Bs, and they have not had to be counted against the cap because maybe they work at an educational institution, but also work at a company. Well, if they can't be cap exempt anymore, then they suddenly are out of two jobs because they've never been counted against the cap. Again, this is, speculation. But, it's based on just some signs that I'm seeing. And the other thing that I'm watching for is, years ago when volume got to be like a lot for the immigration service, they would turn off premium processing. And if they turn off premium processing, it will be another way that, you know, employers will have sort of a lot more trouble having a predictable workforce, because it might be that, when many visa types, when you file for the extension, H-1Bs, Ls, they get this 240-day extension to continue working, based on the fact that the extension is pending. That's, in the regulations. Um, Despite that, if processing times skyrocket to, 250 days and you did not file far enough in advance, and also there's no premium processing. Like, this is another scenario where companies could be looking at, do I have to, put someone on leave? Do I have to remove them from payroll? What is business continuity going to look like? I think the warning is just, let's not forget that this is a possibility and this is something that like the agency has flexed in the past. So open all of the initiation projects as early as you can. I mean, with the government shutdown, it's real cute to say that, right? Because you can't file certified, get a certified LCA right now. But I think, be mindful of all of that and make sure that you're filing in advance. And even if that means that, you have to file an amendment later because someone's job changed, like maybe you do promotions once a year. Well, it might not make sense if it's going to cause you to lose a bunch of your employees, from some period of time because you can't get, their extensions approved in order to keep them work authorized.
All excellent advice. I'll add to it on the data sharing piece. When the government reopens, keep an eye out for an announcement within a month or two after that happens. That's just a informed prediction that I'm giving the audience based off some things I've heard. And then on premium processing, that and the potential suspension for certain case types, that's coming a lot faster than I think people are ready for. So just final plug here, and Lynn, thanks for bearing with me on it. If you're a practitioner and you're interested in knowing more and being able to prepare and look at the real-time USCIS case processing data, in conjunction with the consulting of former USCIS executives. Subscribe to Lawfully Intelligence. You can reach out to me. You can send me an email. We can get you set up a subscription super quick, and you'll get all of that data in your inbox. And then you'll also have the ability to talk with these former USCIS folks that we've partnered with as part of that subscription. So, Lynn, I'll end it there. Thank you so much for taking the time to join me today and recap the news. You had a ton of really, really great insight that I know our listeners will I hope they listen closely because they can get a lot out of it. Any final notes before we go? Where can people follow you? Follow if you post on LinkedIn, follow your blogs, things like that.
Yeah, so I'm on LinkedIn. Feel free to shoot me a message. You can follow me. I typically post client alerts there if I think, it will be helpful, especially to individuals and companies. If you want to sign up for, a client alert so you get it the second it comes out from Womble, like, you can let me know on LinkedIn. I mean, I could send a link for them to sign up, but honestly, I would love to just hear from people and they could tell me like if they were going to strategize a certain way. Like I love benchmarking too. So don't be a stranger. Feel free to reach out to me. I could pontificate all day long on what is going to happen. And also, like, I love to know whether or not theories go from, well, these are the Washington whispers that I'm hearing to, yep, it's totally happening. Today's the day. So,
Yeah.
yeah, thank you.
Amazing. We'll put your LinkedIn profile and the link to your firm's website in the show notes so folks can go and check that out. Well, Lynn, thank you again so much. We'll have to have you back on again soon. And yeah, thank you.
Thank you.